There's a one-page letter that costs less than $10 to send, and that is backed by the full enforcement authority of federal law. Once a debt collector receives it, they are legally prohibited from contacting you again. Not discouraged, not advised against it, prohibited. The law does not say they should consider reducing contact. It does not say they should try to be respectful of your wishes. It says they must cease. And if they violate that prohibition, each violation exposes them to a lawsuit in federal court, where you can recover actual damages, statutory damages, and attorney's fees, all payable by them. The letter is called a cease and desist communication directive. Its legal foundation is Section 805C of the Fair Debt Collection Practices Act, codified as 15 USC Section 1692C cease. And the $13 billion debt collection industry has spent decades hoping that the 32% of Americans who carry debt in collections never learn it exists. The average American receives an estimated 14 collection calls per month when an account goes delinquent. That is 14 intrusions into their day. 14 moments of stress, anxiety, and financial shame manufactured by an industry whose entire business model depends on psychological pressure. The industry trains its agents on scripts designed to create urgency, fear, and compliance. Pay now or face consequences. Your account has been escalated. This is your final notice before legal action. These are not statements of fact. They are performance. And the performance ends the moment a single letter arrives with the right citation on it. Welcome to the Invisible Ledger. If these stories matter to you, hit subscribe and the bell. This is where we trace the money they told you not to follow. The Fair Debt Collection Practices Act was signed into law on September 20th, 1977 by President Jimmy Carter. It was the product of years of documented abuse by debt collectors that had been cataloged in congressional hearings throughout the mid-1970s. Collectors at that time operated with virtually no federal oversight. They called employers. They called neighbors. They called family members. They made threats that had no legal basis. They contacted debtors multiple times per day. They used obscene language and racial epithets. One set of congressional testimony described collectors who called a debtor's workplace every hour until the debtor was fired. Another described collectors who showed up at a debtor's home in the middle of the night. Congress created the FDCPA to establish a floor of conduct below which no collector could legally go. The act was modeled in part on the Federal Trade Commission's existing authority over unfair and deceptive trade practices, and it was administered by the FTC until 2011, when the Dodd-Frank Wall Street Reform and Consumer Protection Act transferred primary enforcement authority to the newly created Consumer Financial Protection Bureau. The FDCPA applies to third-party debt collectors, meaning it governs collection agencies, debt buyers, and attorneys who regularly collect debts, but generally does not apply to the original creditor collecting their own debt. This distinction matters because it means the cease and desist provision applies most powerfully to collection agencies and debt buyers, the entities most likely to contact you aggressively about old or disputed debts. Section 805C is the cease and desist provision. Its language is precise and unambiguous. If a consumer notifies a debt collector in writing that the consumer wishes the debt collector to cease further communication with the consumer, the debt collector shall not communicate further with the consumer with respect to such debt. The exceptions are narrow. After receiving a cease communication notice, the collector may contact you only to notify you that further collection efforts are being terminated, to notify you of specified remedies such as filing a lawsuit, or to notify you that the collector or creditor may invoke specified remedies. That is it. 3 narrow exceptions and an absolute prohibition on everything else. The mechanics of enforcement are what give this provision its teeth. Under 15 USC Section 1692K, any debt collector who fails to comply with any provision of the FDCPA is liable for actual damages sustained, statutory damages of up to $1,000 per lawsuit, regardless of whether actual damages can be proven and in a class action, statutory damages of up to $500,000, or 1% of the net worth of the debt collector, whichever is less, plus the costs of the action and reasonable attorney's fees. The attorney's fees provision is particularly powerful. It means that consumer rights attorneys take these cases on contingency, meaning they take the case for free and are paid by the losing collector if the case succeeds. You do not need money to enforce your FDCPA rights. You need a violation and an attorney. Before I go further, this video is just the surface. Inside the Invisible Ledger Vault, you will find the complete cease and desist letter template with every required element, the FDCPA violation documentation guide, the list of the 37 other FDCPA prohibitions you can use to build a case, and the directory of consumer rights attorneys who take FDCPA cases on contingency. The link is in the description. But stay right here. The debt collection industry is aware of the FDCPA. They are required by law to train their collectors on it. But awareness and compliance are different things. The Consumer Financial Protection Bureau receives more complaints about debt collectors than about almost any other financial industry. In 2022, the CFPB received approximately 150,000 complaints about debt collection, making it the second most complained about category behind credit reporting. The complaints allege collectors who call multiple times per day, who contact third parties, who make false threats of legal action, and yes, who continue calling after receiving written cease communication notices. Why do they continue? Because the FDCPA is self-enforced. No government agency is automatically notified when a collector violates the act. No automatic penalty is imposed. The consumer must identify the violation, document it, and either file a complaint with the CFPB or file a lawsuit in federal district court within 1 year of the violation under the FDCPA's statute of limitations. Most consumers do not do either. They endure the calls, they pay debts they might not owe, they accept harassment as an inevitability. The industry profits from this compliance gap. The cease and desist letter closes it. If you have made it this far, you already know more about Section 805C than the vast majority of the 70 million Americans who have accounts in collections right now. Subscribe and share this video. Now let me give you the exact steps. Step 1. Draft your cease and desist communication notice. The letter must be in writing. It does not need to use the exact words cease and desist, but it must clearly communicate that you wish the collector to stop contacting you. Include your full name, current address, the account number or reference number if known, the name of the original creditor if known, and a clear statement that you are notifying the collector in writing that you wish them to cease all further communication with you regarding this debt. Reference Section 805C of the Fair Debt Collection Practices Act, 15 USC, Section 1692CC. Step 2. Send the letter via certified mail with return receipt requested. This creates a legal record of the date the letter was sent and the date it was received. Keep copies of the letter and the certified mail receipt permanently. Step 3. After the letter is received, the collector is legally prohibited from further contact beyond the 3 narrow exceptions. If they call you after the delivery date, document the call, note the date, the time, the name of the caller if provided, and exactly what was said. Step 4. If the collector violates the prohibition, you have a federal FDCPA claim worth up to $1,000 in statutory damages plus attorney's fees. Contact a consumer rights attorney. The National Association of Consumer Advocates maintains a directory at NACA.net. Many of these attorneys take cases on pure contingency with no upfront cost to you. Step 5. Simultaneously, file a complaint with the CFPB at Consumer Finance, Gov, and with the FTC at Report Fraud. FTC, Gov, these complaints create official records and trigger regulatory attention, particularly if multiple consumers report the same collector. Step 6. Understand what the cease and desist letter does not do. It stops communication. It does not stop the debt from existing. It does not stop the statute of limitations from running. It does not stop a lawsuit from being filed. If the collector chooses to sue, they can. The letter eliminates harassment. It does not eliminate the underlying obligation. The total cost of this letter is the price of a stamp and certified mail postage, approximately $7 to $10. The potential benefit includes elimination of collection calls, potential federal lawsuit recovery of up to $1,000 per violation, plus attorney's fees, and the psychological freedom of knowing that every call after delivery is a violation you can monetize. I need to be honest with you. The cease and desist letter is a powerful tool with real limitations. First, it only applies to third-party debt collectors under the FDCPA. If the original creditor is contacting you directly, the FDCPA may not apply. However, many states have their own debt collection laws that extend similar protections to original creditors. Second, sending a cease and desist letter does not prevent the collector from filing a lawsuit. In some cases, removing the option of continued phone contact actually accelerates litigation, because a lawsuit is the collector's remaining enforcement tool. Know your statute of limitations situation before sending the letter. Third, the letter does not make the debt go away. If the debt is valid and within the statute of limitations, the collector has legal options beyond phone calls. Fourth, some collectors interpret the letter as licensed to simply sell the debt to another agency, which then contacts you fresh. The new agency must receive its own cease and desist letter. Fifth, in some jurisdictions, courts have held that a cease and desist letter, combined with a debt dispute letter, can be more powerful than either alone. Consider sending both simultaneously, citing Section 805C and Section 809 of the FDCPA together. Your grandparents never received a debt collection call, not because they never had debt, but because debt, when it existed, was a local matter between people who knew each other. The creditor was a neighbor, a merchant, a banker from the same town. Social norms governed the collection process. There was shame in aggressive collection because there was community. Then the debt industry scaled, consolidated, and industrialized. Collection became anonymous, algorithmic, and remorseless. 14 calls a month from strangers, reading scripts in call centers thousands of miles away, pressing on wounds they had no part in creating. There was not a more humane system. There was just a smaller one, where human decency had no choice but to govern because everyone involved was looking everyone else in the face. The FDCPA was Congress's attempt to legislate what geography and community once enforced naturally. One letter, $10, and the calls stop. Subscribe and share this video. Every share puts this letter in the hands of someone whose phone is ringing right now. The next vault opens soon, and what is inside will reveal how the wealthiest families in America are using a structure that has been hiding in plain sight since the 1800s to pass wealth to heirs without a single dollar going to the government.